Another guy I used in Simi Valley, California, and he did the same thing for me. He mailed out documents to other process servers across the country for me. His name is Jeff, and the last name is Burke, Berke. I used him to serve Recon Trust, the CEO of Recon Trust, and his number is 805-201-9750. And again, that's 805-210. I apologize. I'm looking at this wrong. Okay, 805-210-9750. I am sorry for misleading you. Who said that? Okay, I got one more guy. This man is the one I used. He's in Virginia. His name is George, and he served MERS for me, and his number is 410-415-0133. And again, that's 410-415-0133.
Does George have a last name?
Well, because way back when I was learning to do this, I actually went on to the National Association of Process Servers website, which you can also do. I can probably find it on my laptop for you and get you that. I just didn't pull it up yet. But I looked him up. He was just some guy on there, and I sent documents to him to send out to MERS. So one of the problems that you have is you may have documents that have to go to all different kinds of states, and that's kind of a real pain if you don't have a lot of time to ship them out to every different place and research and call them. So I'm just trying to make it easier. I have a couple guys that will do that for you. Or you can go to the National Association of Process Servers website, look up these people. The other thing is when you're trying to find your defendants and where they are, you can search the Secretary of State of your state, and it should give you the statutory agent for the defendant's company. Arizona Corporation Commission first? Okay. 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 Yeah. And you're right. That's actually what I did. I said it wrong. Okay. Corporation Commission first. Like here it would be the Arizona Corporation Commission. You do a search for the Recon Trust there, and you'll find that it's not doing business here in Arizona. So then you have to find out where they do business. Yes?
What was George's last name?
I don't know. I don't know. I just have him in my phone as George. Yes.
What's the pacer.com?
Oh, yes. Pacer. Yeah, I meant to tell you that. Where's John? John had my note paper, but anyway. Okay, if you go to Pacer, Pacer, just type in that word. I think it's pacer.gov, but you type in that word, you'll come up with Pacer. It is a search program that you can find every case going on in federal court, and you can actually search and find my case. If you want to track what I'm doing and every document I file and everything they file back and forth on me, and you'd really probably be able to follow exactly where I'm at and what I've done. If you want to take this information down, I'll give you how to find my case on Pacer. So basically, you sign up for Pacer. You have to put a credit card in. They charge like so many cents per page if you print out anything. 8 cents? Okay. I usually just view it for free, but you can, I don't know, you can pay if you want to print it out or whatever. But if you look my case up, there's a scroll down menu. You scroll down till you see Arizona, and then click that, and then at the bottom it'll say like party name. That would be me. Put in Cynthia, which is Cynthia, and my middle initial is J. I don't know if it asks for that. And last name is Cantrell, Cantrell. I think the way you got to do it is Cantrell, Cynthia, and you have Arizona up there, and then it'll bring up my case, and you can follow everything that I've done and everything that I'm doing up to date. So the other thing, if you really need help, and I don't want to get 100 emails, but if you want my email address, I'll give it to you if you're in a bind and you need something that you think I might have. My email address is kind of odd. First name of my email is Jason, Jason. It's my ex-husband's name. I know. Okay, and then it's followed by CIN@AOL.com. So it's jasonsin@aol.com. I've had it forever, and if I change, everybody will lose me. So the other thing, yesterday I gave you the name and number for Charles Horner, the forensic examination guy. Anybody need that number again? Okay, I'll give it again. It's Charles Horner, and it's 619-475-8412. And, okay, I think that's it. Any other questions? Oh, you have them? You know, maybe Bill, when he gets up here, can explain exactly what he does. He has a copy of my examination, and if Bill gets you everything that Charles Horner would have gotten you, great. That's fine. I personally haven't seen a report from Bill yet. He's in the process of preparing mine. So since I didn't know Bill at the time, I hired Charles, and then I hired Bill after. So having not seen one of Bill's completed reports, I don't know what's different in them. Maybe Bill can explain it. Sure. I have it. Can you not hear me? Oh, okay. All right. His question was, what was different between Charles Horner's examination and the examination you would get from Bill? That was his question, and my answer was, I'm not sure because I haven't seen Bill's report yet. He's in the process of completing mine. So since I had already used Charles, I gave Bill a copy of my report, and then he didn't have to do as much legwork on mine. Yeah. Okay, Charles provided 2 different examinations. The first one cost $395, and it was an examination of my original loan docs, my original mortgage loan docs, my note, my deed of trust, all the crap they give you when you go to title. And he went through those and made discoveries of things like overcharges, underquoting of what the interest rate was going to be, TILA violations, failure to give me certain documents in certain times that I was supposed to get them. I can't remember. There was 15 counts of TILA violations. And then there was something wrong with something the title company didn't provide, and that was a RESPA violation. He lists all those, and he does it in a Word doc that you can cut and paste from and put them right into your documents. Then he follows that up for an extra $100. He did a foreclosure examination for me. And currently he is on the fence as to whether or not you should do one if you're in a judicial state, because he believes that in a judicial state you don't need a foreclosure examination because the documents have to be right. Because it's judicial, they have to prove that they have title, or the chain of title's there. But in a non-judicial, they don't. So he does a foreclosure examination, and in my case, he made the discovery that my assignment deed of trust, my substitution of trustee, and my notice of sale were all done in the same town of Texas and notarized by the same notary on the same exact day, and then recorded at the exact same second of the same exact day. And since these documents were supposed to be signed by employees of 3 different companies, how were they all signed in the same town of Texas on the same exact day? You know what I mean? So he kind of went through and called that fraud, malfeasance, and perjury, and gave me a pretty good report about that. So that's basically what he does. He will not testify for you. He doesn't do that. So that's why I hired Bill.
What Bill does.
Yeah, Bill does, wherever Bill is. So is there anything else?
I just want to ask you, because did you provide all your documentation on your own or somebody? Okay. When you provide the documentation to Charles, do you have the original in your possession, all of it, or he has to search some of it?
None of what I gave Charles was any original. I just faxed him over copies of my stuff. But then he went to Maricopa County website and was able to pull from the county recorders the substitution of trustee docs and the assignment and the notice of sale. He pulled that. That's like public information. You can pull that from anywhere. Yeah. Was there anything else? Okay.
Let's take 10 minutes. We'll come back in. We're gonna start the court thing. That'll go on for about 15 minutes. Then Bill's gonna take a stand, and we'll go through. I'll be the plaintiff first to do the pleading for it, and then city
Sit the hell down. I gave you 5. Okay, there was something I forgot to mention earlier. There's I'm not going to go into the whole administrative procedure, but there's still a concept in law of offer and acceptance, rebuttals, all that. We've gone over most of that. Here's an issue. A lot of you, whether it be through a QWR or some other process, obtained a copy of a note. How many people have done that? Okay. How many people obtained copies of notes with that silly stamp that says pay the order of some kind of endorsement and without recourse? What should you do with that? What did they do when they did that? No, not the allowance. Oh, I must have been at a different group yesterday. I'm going to go find that one.
They already cashed it. They discharged the debt.
No, no, no. They discharged, I'll go ahead and say this because one of us has got to be right. They discharged the obligor from the obligation. Do we got that? When they stamped it, they turned it into a check so that they could sell it and then make the deposit, blah, blah, blah. But when they did it, they altered or modified the note. We got that, right? Then they discharged, excuse me, I was talking. Then they discharged you from that promissory note. Let's say that promissory note was $500,000. If somebody gave you $500,000, or in this case a house, and then they said, oh, never mind, keep it, and you were a polite person, similar to me, what should you do in the normal course of business and etiquette?
Send them a thank you.
Now, what happens if you send them a thank you letter acknowledging that they knowingly, I'm going to say these words, and you can choose not to write them down and spank yourself later, knowingly, intelligently, and willfully, with full knowledge of the consequences thereof, I'll say it again, knowingly, intelligently, and willfully, with full knowledge of the consequences thereof, or in a contract case, therein, knowingly, intelligently, and willfully, with full knowledge of the consequences thereof. In a document case, it might be with full knowledge of the consequences therein, but thereof is always appropriate. That they have discharged you of this obligation. Now, we discussed yesterday the requirements of rebuttal under acquiescence and USA v. Tweel, Connolly versus General Accounting. I think everybody has that concept at least. They discharged you. You wrote them a thank you letter. What happens if they don't ever deny that thank you? They've got a problem. They've got a problem. They've got a problem they can't undo. Yes. Okay, then you probably got an earlier version of the note. Diane wanted to know what if they didn't stamp it? What she really is saying, what if you got an old copy of the note as opposed to a current copy of the note? Then you write them again. Yeah, and they did stamp yours.